Yes, good morning, Mr. Mullin.
Good morning, my lord. Good morning, my lords. May it please your lordships, I represent the Appellant Local Housing Authority. I'm leading Mr. Mayor, my learned junior, my learned friend Miss Davies, and my learned friend Mr. Marshall Williams represent the Respondent, Miss Bano. My lords, I'm hoping you have three bundles: a core bundle of 163 pages, a supplementary bundle of 62 pages, and a lengthy authorities bundle.
Well, my one's, yes, 62 pages, yes.
I'm grateful, my lord, and an authorities bundle of 473 pages. My lord, this is an appeal from the order of Deputy High Court Judge D.S. King's Counsel, as he then was, an order made on the 25th of March 2024, following a hearing in January of that year. Permission to appeal was granted by an order of my Lord Lord Justice Newey, on 7th of May of last year. My lords, I don't think there's any housekeeping matters arising unless there's anything.
No, we didn't spot any, and we've had a good opportunity, obviously, to read the key documents, and look forward to having help from both of you, because it's an area in which obviously we know a certain amount, but it's not altogether straightforward.
My lord, no. And I should say my learned friend relies on a replacement skeleton argument, but also a supplementary skeleton argument for which permission has been granted.
Right, now I may need to track that down. I have a replacement skeleton argument of the 9th of January.
My lord,
it's the same date, my lord. We have hard copies. It's very short, and in fact it doesn't contain argument. It just informs my lords of two developments since the skeleton was...
All right, well, just to save time and me scurrying around in this, would you mind passing it up, and I'll absorb that. I may or may not have seen it. I just can't remember at the moment.
I have two copies for the moment. I'm grateful. 3 copies.
Right. Can we assume the third reading of the bill did go ahead on the 14th?
The third read, it did, and it's now in the Lords. And there were no relevant amendments on the 14th of January. There were some amendments, but not in relation to the Housing Act 96.
Yes, thank you. Good.
So, my lord, my plan was to structure my submissions in this way, which was to briefly run through the documents, although if the court is satisfied that it has...
No, I think you can just develop it in your way, because in some senses it's an odd case in that this appeal arises out of judicial review, but it doesn't seem that the parties are agreed about what, if any, decision there was, and whether the judicial review was in respect of the correct decision or a different decision. And so I do think that we need to go quite carefully through the actual sequence of events so that we have your submissions in focus when we do that. So don't cut corners in that.
Very well.
regard.
I'm grateful, my lord. I'll start then, if I may. And really, given the way the supplementary bundle is put together, it is starting at the beginning of it and running through.
Right.
The first relevant documents, my lords, is the Section 184 decision. Of course, there would have been a series of earlier documents and decisions in the run-up to that, but the Section 184 decision, which is at page 3 of the supplementary bundle and is dated the 23rd of February 2017, sets out that the local authority decided that the respondent was owed the main housing duty under Section 193 of the 96 Act. And really its contents are only relevant so far as I say, at least. On the first page of that letter, your lordships will note that there's a series of bullet points, and they set out to notify the appellant as to when, what circumstances the main duty will come to an end. And the third bullet point is you refuse an offer in the private sector. really, that's all that the court needs to have regard to in my submission in relation to the Section 184 decision. The next and perhaps the key document, so far as this case is concerned, is at page 5 of the supplementary bundle, and is the offer of accommodation, which the local authority intended, and I use that word very deliberately, intended to result in the main duty coming to an end. And the contents of this letter will be addressed in some detail in submissions, and why I say, my lords, that time for challenging the legal error that's at the heart of this case began to run from the date of the offer. The offer, as I'm sure the court will note, it is intended to run through the various statutory preconditions, and again I'll come to those in more detail in submissions, the various statutory preconditions that result in the main duty coming to an end, whether that offer is accepted or refused. And it deals with that in a logical format over the next 6 or 7 pages. Now the next two documents, I think it's exception in the bundle in reverse order. So turning to page 14 of the supplementary bundle is an email, as I understand it, from the respondent's, a WhatsApp message from the respondent's daughter.
Sorry, before we go on from the 11th of June, could you just help us to focus on the relationship of this with the Norton decision?
Yes.
Could you just explain to us in broad outline what is in here that Norton says is required and what is not in here that Norton says is required?
So ground A of Norton required, found that where section 193 requires that an applicant is informed of the contents of section 195A, that includes both subsection 1 of section 195A and subsection 2. Now, what had been happening, and maybe this is uncontroversial, is that local authorities obviously operate template letters for these sorts of offers and throughout the homelessness process. And local authorities had taken the view, certainly more than one, because see Haringey had and the London Borough of Waltham Forest had, that it only needed to put in subsection 1 of section 195A in its template letter in order for it to meet the requirement under section 193. And as I say, I'm happy. I can explain all of that, my lord, in a little bit more detail, but in due course. But what this court found in Norton was that failure to include the wording of subsection 2 of section 195A in an offer letter invalidated the offer in short form. So whether that offer was accepted or refused, the main duty continued because the offer was invalid. Right, and in answer to my question, is there reference to 195 in any shape or form in
yes,
this letter? There is, and it is not. Yes, it's page 6 and C. Yes, so on page 6C, I must also inform you of what will happen if you become homeless within 2 years of acceptance of this offer onwards, and that we say was sufficient to set out what's required.
So what are you saying, that C is a paraphrase of 195A1?
Yes, indeed.
But not, without us needing to go there, 195A2?
Indeed, my lord.
Right, so insofar as we're bound by Norton, then it is the missing 195A sub 2
Yes.
has not been referenced in this letter.
My lord, yes.
Thank you.
As I say, I'll come back, my lords, in relation to the other parts of the offer letter in my submissions, but I say it fulfilled, other than the Norton point, if I call it that, it fulfilled all of the other, in my submission, statutory preconditions that were required for the main housing duty to come to an end upon the acceptance or refusal of a private rented section offer.
Right. So again, you'll take us to this later, I know, but while it's in the air, does Norton say that a letter of this sort is invalid even if it's accepted? I think you said something to that effect a moment ago. Is that the logic of Norton, namely that you can be rehoused and that main housing duty still continues?
Indeed, my lord, yes, because the way that section 1937AA is expressed.
Well, at the moment, just an answer will do, because
Yes.
I don't. We'll come to that in a moment, what it actually says.
Very well, my lord.
Right.
Yes, the answer is that's right, because the main duty can only come to an end under the gateways of section 193. For the section 1937AA gateway to operate, the statutory preconditions have to have been, and it operates whether the offer is accepted or refused. But for it to operate, the statutory preconditions have to be met.
Right. Thank you.
So, my lords, after the offer letter, the next document in the bundle chronologically is page 14 of the supplementary bundle. And that's a WhatsApp message from the respondent's daughter, which says, as a family, we cannot move to Derby as this has been our decision from day one. In response to that WhatsApp, there's a letter on the previous page, on page 13, that is addressed to the daughter and says, thank you for your text. As requested, any further correspondence will be via email. As I stated in the offer letter, the council's duty to your household has been discharged, whether you accept the offer or not.
When was the WhatsApp? What date is it?
It's the same date.
So that's the 14th.
The 14th of June.
14th of June. Thank you.
Great.
On a small point, I don't think any of these documents are OCR.
No.
I'm not able to mark them up.
Oh, I'm sorry about that.
No.
For future
I can arrange for them to be
Well, no,
OCR.
it's fine, but I just for future reference, it makes it very difficult to work.
Could you pass that on? It's the same for the core bundle.
I will, my lord. I'll pass that on.
Right. So 14th of June is the WhatsApp, and 14th of June, 5 to 7 in the evening, is.
Yes, and there's an email from the senior private sector lettings officer, which says that temporary accommodation has been cancelled from tonight, which means you're required to look for your own accommodation from tomorrow if you're not accepting the offer made. I'm aware that you're all very upset and nervous about the offer being out of London. However, I've made the council's position very clear. I've also advised you the reason for why you have been made the offer. So what's common ground, what happened after that, is that there'd been some, for the 15th of June, there'd been some travel arrangements made to go to Derby, and that the respondent didn't travel and didn't sign up for the property. So that is the relevant refusal takes place between the 14th and the 15th of June 2020. Do
you mean the refusal is not just in the WhatsApp, but also in the cancellation of the moving arrangements?
Yeah, it's a continuing refusal, if I put it that way, my lord. Yes, so in my submission it starts in the WhatsApp and is maintained, because I think reading the 14th of June email, it would have still been possible to have accepted it up to the following day at least, up to the 15th, when the travel arrangements were still in place. But the refusal, I say, started on the 14th. Yes, my lord.
So if the 14th of June email keeps alive the offer, then the council hasn't definitively decided that its duty has come to an end.
Well, if there is no, it hasn't, because although one could argue, my lord, that if the refusal starts on the 14th, regardless of what the council decides, and this is a point in the case indeed, is whether the duty ends at law by virtue of the refusal, or whether there is some formal decision required from the local housing authority that has an impact on whether the duty stays alive or not.
But there's also the possibility, I suppose, I just throw this out, not suggesting that it applies here, that that there has in law been a refusal, but that the council is operating indulgence.
Yes.
For common sense reasons.
Yes, well, and I think once the offer is refused, the duty comes to an end, but the offer being reopened, as my lordship says, as an indulgence, if it were accepted at that point, then it wouldn't be the case that the main duty had arisen again and ended again. It would just be a case that the original offer had been accepted late after the duty had come to an end. So the offer would go on for a little bit longer than the duty. I think in my submission would be
So those are the sort of an indulgent offer which they weren't legally obliged to make, but which, if accepted, would take effect for some other reason.
My lord, yes. So if the initial refusal would have, in my submission, would terminate the main housing duty, but a subsequent acceptance would still result in the housing applicant being housed under the assured short hold tenancy.
Right. In other words, you can not only have a duty, but presumably a power.
Yeah. My lord, yes, I'd say so. Yes.
Another way might be another way of putting it.
Yes, I'm grateful, my lord. My lords, the next document in the chronology is on page 15 of the supplementary bundle. It's a letter of the 19th of August 2020. And it's a letter about the cancellation of temporary accommodation.
Right, so they had been in temporary accommodation for some years, including
Yes.
through COVID.
My lord, yes.
Right, so the 2 months when nothing happens, they stay put.
My lord, yes.
They don't move, and you then take the initiative.
Yes.
On the basis that this can't be allowed to run on.
Yes, and the specific again, I don't think this is disputed. The specific mechanics of this is that the local authority arranges for a private provider to provide the temporary accommodation. The local authority, when it decides it no longer owes somebody a duty, it cancels the temporary accommodation, and then it is for the private provider to bring the possession proceedings, or indeed keep the person on if they see fit. In that temporary accommodation, but the local authority's responsibility ends at the point at which it cancels the booking. With that,
from then on, the temporary tenant addresses the landlord.
Indeed, my lord. That is dealt with very briefly indeed in the witness statement that was before the court below of Mr. Egbum, which is. Page 51 of the supplementary bundle. And he says at paragraph 3 of his witness statement onwards, he makes his statement to clarify that the accommodation at 8 Ling Road, which is the temporary accommodation, which has been and I believe continues to be occupied by the claimant, Mr. Bano, was procured as licensed accommodation. The council does not have a material interest in the property. Ms. Bano is not being accommodated at the property by the London Borough of Waltham Forest. And then it says Ms. Bano's application was closed bracket section 1932 duty ended by the offer of PRS which she refused, close bracket. She remained in the property without permission from the council.
Was that the property that she remained in until a possession order was made in November 23?
My lord, yes.
So 16th of November 2023, possession order as between the private individuals,
Yes.
and the warrant of possession was executed on the 21st of March 2024,
My lord, that's right.
from something I've read. I think you'd tell us that.
Yes.
And so, just stepping back, I appreciate it doesn't help us a bit with the issues we have to decide. If it was the case, and we have no information about this, that Miss Bano, who by then has adult children, no longer minor children, is subject to a possession order from this property in March 2024, does she then become eligible to start the process up all over again if she should prove to be homeless?
I think the answer, my lord, is potentially depending on her circumstances, but we couldn't say definitely that she would be.
No, but it's theoretically possible that that there might be a completely different situation to be dealt with by your or some other authority.
My lord, yes.
And my lord, I'm sorry to interrupt,
Not at all.
but since my lords are dealing with the factual position, I can tell my lords that following the execution of the warrant, Waltham Forest arranged for accommodation for my client, first in one place, I don't have the address, and actually very recently, last week, they moved her to a different place. It's not for my lords to determine the nature of the duty or power under which they have done so,
Not at all.
but that is factually what has happened. She remains in accommodation that has been arranged by Waltham Forest.
Right, and would that be in the nature of temporary accommodation?
It's said to be under section 193, so yes, it's not a secure tenancy.
I see, so,
I don't know if it's an assured short-hold tenancy off the top of my head, but I can
right, so
find out.
it's said to be in performance of the main housing duty.
Yes. I have a document saying that.
Right, so
which leads to, so there is clearly, subject to my lord's decision in this case, but there will clearly be some discussion between her advisors and Waltham Forest about what happens following your lordship's judgment. But it is said to be temporary accommodation and said to be an offer under section 193. That was made last week.
And is that within the borough as it happens?
It's in Dagenham.
Right.
It's close to the borough, but not within the borough.
Right. It's always interesting to know whether by the time an appeal gets to us, it's completely academic, so far as the individuals are concerned.
Yeah. And in between March last year and last week, she was in a hotel in Romford, so that was temporary accommodation. I'm looking at the address.
That was the first place you were talking about, and this.
Yes.
And the second place is Dagenham.
Is Dagenham.
But it is said to be temporary.
It's said very clearly to be temporary and under Part 7.
Right, so it's not entirely theoretical for her because she might be asked to move to Derby.
She may well be asked to move to Derby, yes. Right. Or she may, again, subject to my lord's decision, at some point Waltham Forest could take the view that the Section 193 duty had come to an end to her back in 2020 and she should leave this accommodation. And no doubt there will be argument then as to whether subsequent events had changed your lordship's interpretation of what happened in 2020, but that's not for this court.
No, but to close off this discussion, Ms Barnow's current interest in the matter resides primarily in the applications that she's made and have been to an extent accepted by this same local authority. What we say about the theory may be of interest, but really the boat that she's currently embarked upon is a different boat to the one that we're now.
She wants to remain in temporary accommodation and be given a suitable offer of permanent accommodation. That's clearly what she wants.
All right. Well, thank you for
that. My lord, yes. So the final paragraph I'd refer your lordships to was paragraph 6 on page 52 of Mr. Egbon's statement. So just confirming what I've told before. that the temporary accommodation contracts team is not seeking to evict Miss Bano as she was placed in a licensed nightly let accommodation, and the accommodation is not the council. So that's reiterating my Lord's position I've explained.
And this is all prior to the eviction, isn't it?
Indeed, my Lord. Yeah. The next is at page 16 of the supplementary bundle. This is a letter from Ms Bano's former solicitors, not those that are instructed on this appeal. And this is a letter dated the 29th of September 2020, so we've moved a little over 3 months from
28th of September.
Sorry, 28th of September 2020. And we've moved a little over 3 months from the date of the offer. And the letter's entitled as a request for review and a request for temporary accommodation pending review outcome. And I don't think I need take your lordship to the specifics of that letter, because that's it. What matters in my submission is what it's seeking to do, and its context for the next local authority letter that comes back the other way, which I rely on. But in essence, the letter says that they'd understood that a review had already been requested as regards suitability. And sets out the chronology that I already have, that I've already set out to the court about what happens on the 12th, 14th, and 15th of June.
Sorry, I'm just. This is. Are we in the letter of the 7th of October? Is that what you...
No, we're on that, still on page 16, my lord.
I'm sorry.
So yes, so it sets out on page 16 and then over onto page 17 the chronology I've already explained to the court.
They refer to a WhatsApp of the 15th of June. That's just a mistake, is it? You've told us it was on the 14th.
My lord, yes, I think it must be, because the 14th
because the email responded to it.
Responds so clearly, is so clearly responding to that WhatsApp, yes. And then on the final page of that letter, the third paragraph up, our client informed us she made a review request via WhatsApp message to Miss Yasmin Hussain on 15th of June. We're now instructed to make further submissions on behalf of the client to support her review on why moving to Derby would not be suitable for her family.
Right. So if one interprets the WhatsApp message and everything that was going on then with phone calls and so forth as a request for a review, can you crystallise your submission as to what the relationship is between a review, an acceptance, a refusal in this context?
Yes, so
how do they fit together?
My lord, I shall. So there are, the offer letter contains two decisions which can be the subject properly of reviews in my submission. So the first is the prospective intention that the main housing duty will come to an end upon acceptance or refusal. That would be reviewable under the section 2021B gateway, because it's a decision as to duty.
Is the review carried out by an independent person within the authority?
Yes, it must be so. Yes.
Yes.
So that's the first decision that's reviewable under that gateway. The second decision is that the property is suitable for the offered property is suitable for the applicant, and that's reviewable under a separate gateway under section 202. So the relationship between the refusal and the right to review, there's no direct relationship in my submission. So, because a review always has to be fitted through one of the gateways in section 202.
Right,
So,
but if I say I can't go to Derby, you haven't fulfilled your housing duty, or I can't go to Derby, it's unsuitable, which might be the more relevant gateway.
Yes.
Is that an acceptance or a refusal, or neither?
It would be a refusal in my submission. So saying I can't go to Derby, we've said from day one we're not going to move to Derby, is a refusal of the offer. It's not
on the basis of suitability.
On the basis.
It's not because it's not a big enough flat, or it's not on the ground floor. It's just
Yes, it's unsuitable in terms of its location. It's too far away from my support network where I've previously been living. But that, in a way, the reasons for the refusal might translate into the basis for the review you're seeking. So you could refuse an offer and say, well, I mean, it would be a very technical, lawyerly way of doing it, but you could refuse an offer on the basis that you don't think the statutory preconditions have been met. And so I'm safe to refuse this offer because my refusing it won't bring you'll still owe me the main housing duty afterwards.
Right, and the offer is the offer of the individual property.
Yes.
That's what the focus is.
Yes. So it's the prospective intent. So yes, the part one of the offer that would be reviewable is the prospective intention that the duty comes to an end. And I say and we'll come to it, I'm sure, my lord, in due course, but I'm fortified in that interpretation by both what the learned judge found below initially in his judgment, and having read Ravichandran, where Ravichandran expressly states that there can be a review as to duty prior to a refusal having happened. So there can be a review of the prospective intention that the duty will come to an end on the refusal. There's also a right to request a review of the suitability of that offer, and suitability encompasses a wide range of matters that aren't relevant to this appeal, but it can include location, affordability, the physical characteristics of the property, and so on.
Yeah, this letter from the first solicitors asks you to say whether you're carrying out the review.
Yes. Then there's the 7th of October letter on page 18 of the supplementary bundle, which is as a response to that letter. And that letter goes through again the chronology, the history of the housing application. It says that according to file records, on the 11th of June, Mrs. Bano was made an offer of private rented sector accommodation, 53 Chellaston, Derby, to end main duty, and on the 11th of June, warning letter was issued. The offer letter advised that 1. If she accepts or rejects the suitable private rented sector offer of accommodation, it will discharge the council's duty towards her under section 1932 of the Housing Act 96. That she had a right to request review of suitability, and if she accepts the offer, she continues to request review of our decision, and that the accommodation offered to her is unsuitable under section 2021F, and so on. And it sets out the legal what the legal consequences were in the offer. It effectively repeats the contents of the offer. Then in the final paragraph on that page says, I regret to inform you that section 2023 of the Housing Act states that a request for review must be made before the end of the period of 21 days, beginning with the date on which the applicant is notified of the authority's decision, such long a period as the authority may allow. And effectively the offer goes on to say, well, there was no request for a review. We've got no record of a request for a review.
Just looking back at the earlier correspondence at the time of the offer,
My lord, yes.
was the information about the review? Yes, you have a right to request a review.
Yes,
I'm
that's
looking
on.
at page 6.
My lord, that review is mentioned twice in the offer letter. There's one on page 6 And page 6 specifically says you have a right to request a review of the suitability of the offered accommodation. The reason it says so in those terms is because that's what section one of the preconditions that section 193 requires. And then on the final page, at page 11, also the offer letter also says right to review Housing Act 1996 section 202. If you wish to request a review, you must put this in writing within 21 days.
Is there any particular formality required in making that request?
No. There have been cases about whether something is in reality a request for a review, but no, there's no particular formality. But the case law indicates that it has to invite some sort of reconsideration. There have been cases on both sides of the line that are marginal. So
and the solicitor's letter seems to be relying on the sentence on page 40, we would like to be relocated locally if we're to be moved. And the local authority didn't regard that as a request for a review.
My lord, no.
And it's not been pressed as a point, has it?
No. And there's been no challenge to it. So the route for challenge from the failure to accept a request for review would be judicial review. Indeed, I've been involved in several cases where that's the issue between the parties.
But so your response was that you didn't treat it as a request for a review, and when it was checked up that you were actually reviewing the matter, you said they were too late.
Indeed, my lord. We said they were too late and wouldn't be providing accommodation pending review. I mean, on the basis that there is no review, because we're not accepting an out-of-time request and there was no earlier request. But the reason I rely on this letter, my lord, as I say, it's clear, reading this letter as a whole.
Which one? The earlier one?
Sorry, the 7th of October 2020.
7th of October, thank you.
Reading the 7th of October letter as a whole, it's clear that the local authority had formed the view at that point that the main duty had come to an end. In my submission, it's impossible to read that letter any other way.
At that point, Miss Bano, acting on advice, no doubt, could either have said, well, you're clearly wrong about the review. You were asked for a review and you just didn't do one.
My lord, yes.
Or they could have said that you're wrong about the termination of the main housing duty.
Indeed, my lord. And the judicial review that was heard at the beginning of last year, in my submission, could have been made at any point from the refusal of the offer onwards. Because the legal error that the respondent relied on is the Norton error. And that's it. And that Norton error is contained in the offer letter.
Well, so if we're piling up things that they could have said against you at that stage, it could have been the non-review.
Indeed, my lord.
It could have been the assertion that you'd finished your housing duty in general, or it could have been somebody acting with foresight in relation to what Norton was going to say and making the points that succeeded there.
Indeed, my lord, yes.
Right.
Just going back, you say it would have been possible to bring judicial review proceedings on the Norton basis from any point after the offer letter. Could Miss Bano have requested a review in relation to the Norton point?
She could, indeed, she could have requested an out-of-time review at any stage.
Well, leave the out-of-time bit out of it. Suppose she had anticipated Norton. She gets the offer letter.
Yes.
She looks at it, she sees it's defective. You say, well, she could have brought judicial review proceedings.
Yes.
But obviously, the legislation now envisages that most challenges will proceed by way of review. Could she have instituted a review on the Norton basis?
My lord, yes, and that's a central pillar of my argument, because that would be a review of the letter under the gateway, section 2021B gateway, that Ravichandran says expressly says is permissible prior to a refusal having happened.
And just following that through, if that's right, then she couldn't really have brought judicial review proceedings because they would have been inapposite.
Yes, I expect my primary submission, and in my submission it's a complete answer to this case, is that from the date that the offer was made, there was an alternative remedy to raise the point that was raised in subsequent judicial review proceedings about the validity of the offer. And I think it's accepted that if there's an alternative remedy absent some exceptional circumstances, particularly in housing cases, then permission will be refused, and it's not a matter that the administrative court will determine.
So really, because I think we've now, if we've got everything here, we've now come to the end of this thread.
Just before you do the judge spends some time on the paragraph at page 19, doesn't he? The in regards to accommodation paragraph.
Yes, my lord, and I had invited the court below to consider the letter as a whole. I had highlighted that paragraph because what it says is that the final sentence of that paragraph is, furthermore, we've stated the request was out of time and this council considers itself relieved of its homeless duty towards Miss Bano pursuant to section 1935 of the Housing Act 1996. So what was said against me in the court below was that this must have been a reference to temporary accommodation, because section 1935 is the gateway by which temporary accommodation is, the refusal of temporary accommodation brings the main duty to an end rather than a private rented sector offer. My submission to the court below was that must have been a mistake, because there was no temporary accommodation that was being bought, that had been refused, that was being relied on to bring the main duty to an end. But the learned judge below focused on that point to say that, in effect, that this letter was not a confirmation that the main duty had ceased at all. All it was a response to an out-of-time review request, and that paragraph must have been dealing with some other offer or some other accommodation, not the operative one. I think that's a fair paraphrasing of the learned judge's view. I disagree with that, obviously, because in my submission, this is, when it's put in its context of what are agreed facts. It's agreed that the offer was made. It's agreed that the offer was intended to bring the duty to an end. It's agreed that the offer was refused. Then some time later, solicitors act for Ms. Bano, check if there's an outstanding review, and say if there isn't, we'd like to bring one, and can we have accommodation pending that review? And the local authority writes back and says, no, we made an offer. We told you in the offer that if you accepted or refused it, it would come to an end. You refused it. There's no request for a review, and you're now out of time to request one.
So at that point, everything goes quiet for 2.5 years.
Indeed, my lord, yes.
And so your essential submission, much better expressed, but in a nutshell, is that this was where it was at.
Yes.
That this was when the objectionable decisions, as they were seen by Mrs. Bano and her family, were made.
Yes.
And that was the time that they ought to have been challenged and shown to have been wrong.
My lord, yes. And it can't be right for the reasons that we said in the court below, in terms of time limits, undue delay, and the prejudice of good administration, that challenges of this nature can be brought so long after the fact. Because, as I submitted to the court before, these were problems with template letters that Norton highlighted, and if it's right that no doubt there will have been many hundreds of applicants who didn't challenge those letters at the time, accepted or refused offers of accommodation, and on the analysis that the respondent puts forward, they would all be still owed the main housing duty and able to bring a challenge to that fact by simply writing to the local authority about it, getting in a pre-action letter, getting them to respond to that pre-action letter and then say, aha, now we have a decision that's in time, when the substance of what's being challenged is what happened in June 2020, not what happened in 2023 once Ms Bano had the benefit of
Well, June
advice.
2020 or conceivably October 2020,
Indeed,
if you were all wrong about the review state of affairs.
indeed, my lord, yes.
But at all events, your case is that the remedy needed to be activated within 2020.
Yes, my lord. And that really is our case in a nutshell. But as I say, the alternative remedy point is slightly distinct from the delay in the time limits. But is I say, a complete answer to the case, and it doesn't depend on. So the court could find in favour of that argument, and wouldn't need to actually determine whether the confirmatory decision is required under the statute or not, because it wouldn't make a difference. There would have still been the alternative remedy of a review against the offer. If there had been a confirmatory decision and it had been notified to the respondent, she would have also had the right to request a review of that decision. So the logical progression of our case is that even though it doesn't say there's a right to request a review of the October letter, there would have been one to the extent that it was a confirmatory decision as to duty, or indeed the 14th of June email, which says that the duty is discharged.
And just to be clear, that there's a sort of potential confusion here between decision and notification.
Yes.
And the judge says, well, there is no duty to notify, but there is a duty to decide. Now, when you refer to, say, the October letter, that may or may not be notification. Any decision might have been distinct from that.
Yeah, my lord, yes. And that's, to be absolutely clear, that's my case. My case is that the decision must have happened very shortly after the offer was refused, if not the same day, on the 14th of June. That's because one can see from the context that that's the only position the local authority could have taken. When I say it doesn't have to make a decision, plainly the local authority has to act in a way that is consistent with there having been a refusal or an acceptance of the offer. Where there is a refusal, as in this case, and as in fact everybody did, the local authority acted consistently with the duty having come to an end.
Now, I think you said something to the effect that obviously the local authority must act in such a way.
Yes.
Does that logically follow in your case? I mean, on your case, you make the offer, you decide to issue the offer letter.
Yes.
Which, on your case, under the terms of the statute, will automatically bring the duty to an end.
Yes.
Now, following that logic, why would the local authority have to do anything further? I mean, the duty on that thesis either, would come to an end, either with acceptance or refusal.
Yes.
And that would be that.
And that is my submission. And I'd agree with that analysis. That what practically will have to happen following the refusal or acceptance is, for example, the temporary accommodation will have to be cancelled. Arrangements to travel to the property, if it's a long way away, will have to be made, and things of that nature, all of which happened in this case.
There will inevitably be communication,
Yes, indeed.
either one way, the other way, or both ways.
My lord, yes.
And until there's communication, the time doesn't start to run for the right to review.
Well, the time starts to run from the right to review of the offer when the offer is notified to the respondent, which is the 11th of June. Where a local authority makes a second decision, and my overarching submission on ground one is that Ravichandran and Warsame don't oblige a second confirmatory decision. They just say where there is one, it's reviewable. Where there is a second confirmatory decision, yes, the time limit for a review will start to run upon notification of that confirmatory decision.
But remind us, was the offer of accommodation time limited? Just what's the practice in this
not
respect?
sure on its face.
Do they have a certain period of time to?
Yes, if she didn't go to Derby, it would be withdrawn. There's a reference to 24 hours. It's page 5. The offer of accommodation cannot be held open for you for more than 24 hours.
Sorry.
Thank you.
Sorry, I see it.
I'm grateful to my learning from.
So that's 24 hours beyond the 15th, is it? Or
It's not clear.
no?
Has to be
Yes,
said.
I see. Yes.
The council will assume that you've refused the accommodation offered if you fail to attend at 2 p.m. is the suggestion.
Yes, I see.
My lord, yes, and one of the challenges that sometimes brought and has been the subject of some authority under section 202 and 204 is that I didn't have enough time to properly consider the offer and therefore it's unfair.
All right, I didn't get it until a couple of days later. Or whatever it
Indeed.
was.
Yes. Those sorts of challenges are relatively common, I think.
Just going off on a tangent for a moment longer.
My lord, yes.
So, as you say, in practical terms, you would expect there to be some communications after an acceptance or a refusal. Does one necessarily expect a decision at that stage? I mean, even in a case where the local authority writes a letter saying the duty has come to an end, are they necessarily deciding that, or are they just thinking, well, that's the consequence of what we did earlier?
No, the latter, my lord, in my submission, because that's the way that this. I think it would be impossible to read the statutory provisions any other way, and that's also consistent with the view that this court took in Ravichandran, where it was found that the in my submission, I'm not sure my learned friend agrees with me about this, but in my submission it was found that the ending is automatic. But where there is a confirmatory decision, so the local authority aren't saying by this letter we are ending the main housing duty. The local authority is saying we satisfied all the preconditions in our offer, you refused the offer, and therefore the duty came to an end. Then there are, of course, so the right to review exists both at the point of the offer as to duty and on any confirmatory decision. But if there's already been, and this is the point that vexed this court to some degree in Ravichandran, is to what extent where you have two reviews running parallel do they interact with each other? In fact, it may be worth going at this point in some detail to Ravichandran.
Because we don't need the supplemental bundle anymore. No,
I don't think so, my lord. That's all. I mean, I've already referred your lordships what I say are the relevant documents. There are.
Well, I think it's useful if we go maybe before we're leaving this just to 22, so we see how the issue uprose again.
Yes.
In the message of the 15th of May, 2023.
My lord, yes. So what I assume happened is that Miss Bano, when she became the subject of possession proceedings, obtained advice from Edward Southey. Edward Southey, when reviewing the paperwork and the basis for the possession claim, identified the Norton point, if I put it that way, and they write in May 2023 seeking confirmation that the main duty still applied because it was never discharged. There's then quite lengthy pre-action judicial review correspondence. First letters 13th of June at page 23. There's a response that it was accepted in the court below was erroneous in some respects. At page 28 from the local authority, I think it was sought to argue that Norton didn't have retrospective effect or something along those lines. Of course, it had abandoned that point rightfully by the time the judicial review was issued.
And in the supplemental bundle, where missing are we the decision letter, which is on the face of it the subject of the challenge in the judicial review, because that relates to the 30th of May letter.
Yes, it's in the core bundle, my lord.
Yeah.
which is at page 159 of the core bundle.
Yeah.
So that's 15th. That's the answer to the 15th of May, right?
My lord, yes.
Right. So, could we, before we leave the chronology of communication, just consider that letter?
Yes, my lord. Yes, so there's the 15th of May email at 22 from those that instruct and a friend. Pre-action letter on the 13th of June. There's then some emails.
Sorry, I don't want to hold you back, but I want to firmly understand what it was that your counsel was saying on the 30th of May. Could you just give us the punchlines as you would see it?
The 30th of May, forgive me.
Yes, I'm back in the core bundle at 161 or thereabouts.
Yes. Yes, so the response so there was a request for an out-of-time review as part of the pre-action letter. The 30th of May letter says, we won't be, please be advised, the email dated of 15th of May 2023 will not be accepted as a request for review because your email was received after the statutory deadline. And then it goes through the chronology again. On page 160 at the top, it records the offer letter being made on the 11th of June. Sets out what it says of the contents of that letter, and the court will be somewhat familiar with that recitation by now. Then says in bold at the bottom of page 160, section 2023 of the Housing Act states that request for review must be made before the end of a period of 21 days, with the day on which the applicant is notified of the authority's decision or such longer period as the authority may allow. It's apparent that Ms Bano was advised of the statutory deadline in the
Yes, we can read that. So it's 1,047 days late.
So they make 2 points. One is Norton isn't retrospective, which is a bad point.
Yes.
But another one, the Norton ruling came out in October 2022, which is potentially a good point.
Yes, and indeed one we maintained in the court below. Yes. I mean,
So it's out of time both in relation to the original decision and in relation to any effect of Norton.
Indeed. I mean, not that Norton had an effect in the sense that it changed the law.
But there was an opportunity in the light of Norton
Yes.
to seize the point, and they took a number of months to do so.
Indeed. More than the relevant time limit. And it would have, from when the judgment was handed down, and I think it would have been better characterised as potentially as an exceptional circumstance to extend time. An argument could have been constructed on that basis. It would have still been imposed, but I think it would have, a better way of putting it might have been to say that that's the nature of the exceptional circumstance. There was, of course, and part of the reason, as the court can take notice of, that Miss Bano was in the accommodation for so long before possession proceedings was no doubt the COVID pandemic and the ban on evictions that was in place for some time, because this was all happening right at the beginning of the COVID pandemic.
Right, and at the very end, signing off that the council's duty was legally and lawfully executed, legally and lawfully. Page 162 at the bottom. What duty is being referred to there? Everything.
Yes, well, it must be the main housing duty in my submission, because that's the last duty that was owed, and the council was taking the view at this stage that it had ended upon the refusal of the offer. I mean, it subsequently conceded in the court below that the main duty must have in fact continued after the offer and the refusal.
So what if anything, of that 30th of May communication is a legally reviewable.
I would say none of it, my lord. I would say none of it. It's a pre-action. It's in response to the pre-action communication. It's not reviewable.
It's a statement of position,
Yes.
rather than a decision.
Yes, it's a reiteration of the council's previously
your
stated
case.
position. On my case, my lord, yes.
Right, I'm sorry. Is there anything else that we need to look at in what follows between then and the judgment?
My lord, no, not in my submission.
Right, you wanted to go to Ramachandra?
My lord, yes. So the relevant parts of Ravichandran have been lined, but to set the scene, the subject of appeal, the subject of the appeal in Ravichandran was about what decisions are within and without the Section 202 review gateways, and it had been argued by Mr. Arden, QC, for the local authority, that any decision, because the duty ended automatically, any decision that came after it was irrelevant. Any confirmatory decision that came after it was irrelevant and therefore not reviewable and not appealable. And that's set out. So the court deals initially with a point that's sort of obliquely relevant to this case about the difference between Section 1935, so far as that brings to an end the duty for temporary accommodation, and Section 1937, which was the relevant provision in that case, because there was the local authority were making an argument that they could have relied on Section 1935 to bring the duty to an end anyway, even though it had been an offer of permanent social housing rather than an offer of temporary accommodation. But the court needn't concern itself with that in my submission. Paragraph 28 on page 299 of the authority's bundle, which is lined, sets out on this point, the relevant point.
Sorry,
299 of the authority's bundle.
Yep.
So Mr. Arden's, it may help if the court just reads that line rather than me reading it out.
And then on to 30.
My lord, yes. So just the bit I'd highlight in paragraph 29 is just the sentence after where the lining finishes in paragraph 29 of the judgment. He dismissed as misconceived and irrelevant indications of Lewisham's officers, in particular Mr. Gomez and Mr. Dixon's letters, that Lewisham only decided to regard its duty under Section 1932 as discharged sometime after the applicant's refusal of the offer. So Mr. Arden, and this is where a close reading of this is important in my submission, because Mr. Arden's case was not that it was that the subsequent decision once the duty is finished is not reviewable because the duty ends as a matter of law automatically under the statute. Now, in response, and so it's important to frame because that puts what the court subsequently found in context. Mr. Latham, in response, said that notwithstanding that the implied notification permission had gone from the previous drafting, that it's still implicit that the amended statute prefers the follow result, that following the refusal of an offer, the authority must notify the applicant that the authority regards itself as discharged from its duty under the subsection. Now, both arguments were found to be misconceived. So, but what was misconceived was not that the duty ended automatically or at law. What was misconceived was that subsequent decisions confirming that were not reviewable in my submission. And when one that's where the court relies on Warsami to that effect.
So just to be clear, on your case, the subsequent decision would be of no legal effect.
Well, it would be if yes, a subsequent decision that's been notified to an applicant would be as to duty, including a decision that a duty once owed is no longer owed, would be reviewable.
It would be reviewable, but on your case, it would be legally nothing.
Indeed, yes.
So one might think, well, if it's legally nothing, it's a bit odd if it's reviewable.
But that I mean, one might, but that is, I say, what must be the effect of the court's decision in Ravichandran, because and I suppose it's not legally nothing in the sense if it's reviewable, then it's not legally nothing because it provides an opportunity. If then some error of law is made in the review of that decision by failing to take something into account or any of the other normal public law errors.
But the key thing is whether it's a decision or not. I mean, isn't this telling us? I'm only approaching it, not fully into it, but isn't the key point that decisions are reviewable? But
Yes.
the question is to work out whether something is in fact a decision,
Yes,
or simply a reflection of a decision previously made.
my lord, I'd respectfully agree with that. And it's also what Ravichandran is dealing with is not an obligation to make a decision of any kind. It's saying where there are such decisions, if they're decisions at all, and I take your lordship's point about that, then they are reviewable. But I say Ravichandran actually supports our appeal quite strongly because as we move on to the further line sections over the pages at 301 and 302, the court clearly finds that paragraph 32 that there is one can have a review of a prospective discharge of duty, a decision that's prospective as to the discharge of duty. That's echoed in the summary of principles that's set out at paragraph 35. It's subparagraph 6 on page 302.
That treats the expression of an intention that the offer will result in cessation as a decision, that is the position.
Indeed, and so we say because and the Norton point is necessarily a precondition, a matter of prospective intention, because it has to be in place before the refusal. So that the factors set out at section 193, 7AA and 7AB have to be satisfied in advance of an acceptance or a refusal for the mechanism to operate and bring the duty to an end. So it would have been perfectly possible for Miss Bano to say, once she got the offer letter, actually this offer letter, I'd like a review of the offer letter, please, on the basis of its suitability, because I don't want to move to Derby because it's a long way away, but also because, in my view, the offer letter is defective because it doesn't notify me of what it's supposed to notify me of in section 195A subsection 2. And a review decision would have then had to have been produced. If one wasn't produced, she could have appealed against the original offer decision itself. And she could have made the same points that were made in Norton ultimately to this court.
Are you leaving this case?
My lord, yes, I think subject to those. So I rely on Ravichandran primarily. I think my known friend will probably come back to it in some detail, but I rely on it primarily for that, to establish that premise, that a decision as to a prospective intention to end the duty is reviewable under section 2021B.
Is it worth just trying to understand paragraph 31 as well? So that's harking back to the legislation as it was at the time of Waltham.
Yes.
So although that was a decision under the unamended provisions, which referred to notification, and I think suitability came in at that later stage too, did it, under the unamended provisions?
My lord, yes.
The decision remains applicable to the amended provisions, although worded differently. The original provisions provided for automatic cessation, albeit at a later date. So the thesis there is that even under the old provision, there was an automatic cessation.
Yes.
In the present case, it's clear from the correspondence that Lewisham came to a decision in January about whether its duty had ceased. The effect of Waltham's case is that its decision taken then, even if only confirmatory of a prior automatic discharge, was reviewable. So on your case, this is the court proceeding on the basis that you can have something, a decision that is confirmatory of a prior automatic discharge.
Yes.
And on your case, you say, well, you can have such a decision, but you don't have to have a decision of that kind.
My lord, yes. Particularly, it's unsurprising in a case such as this, on the facts of this case, because everyone is agreed, and has been, I think, from the beginning, that there was a refusal of the offer in question. So the only thing that would need to have been, the only matter that wouldn't have already been set out in the offer in any confirmatory decision would be whether or not there was an acceptance or a refusal. Now, there are cases where that can sometimes be contentious. There's one in the bundle, I won't take the court to it, but it's Nicolava and Redbridge. And in that case, there was a disagreement about whether or not Miss Nicolava had refused the offer. She'd effectively written a series of equivocal letters in response saying, I don't refuse the offer, but I will never sign the tenancy agreement, something along those lines. And the local authority took the view that those amounted to a refusal properly in a letter that post-dated those refusals. That letter that post-dated the refusals was subject to review and appeal.
But going back to Ravichandran at 31, your position is that what is being described there as a reviewable decision is not what took place in this case.
No, my lord. Well, I say there were confirmatory decisions, or that the local authority did decide that the main duty had come to an end. Wrongly, I say, because of the Norton point. But that was clearly the decision the local authority took at the time. What I say in ground one is it wasn't obliged to make that decision. And what I say in ground two is even if it was obliged to make that decision, it did make such a decision, and the learned judge below found it was a decision that didn't need to be notified to the respondent.
So just to be clear, on your case, there was a confirmatory decision, albeit one that was not formally notified.
Yes.
And applying Ravichandran, that confirmatory decision, albeit not notified. Well, actually, how does that play out? The confirmatory decision, albeit not notified, could have been the subject of a request for a review.
Yes.
Does time run for a request for a review where you've made a decision but not notified it?
No, time runs under section 202 from the point you're notified of the decision which you want to review.
So on this thesis, you make a confirmatory decision.
Yes.
Sometime in the latter, between June and October 2020.
Yes.
When did time run out for a review of that decision?
Well, it's a decision on. So we say that once the decision is communicated to the appellant, the decision on refusal, that there'd been a refusal and the duty had been discharged, was communicated for the first time, I think, to the respondent. Sorry, on the 14th of June, in the email of the 14th of June. There's then the letter of October 2020 as well, both of which are clear confirmatory decisions, which include confirming that the local authority is.
So in your case, you have to say, do you, that the subsequent letters, is it of August and October really, amounted to notification of a decision?
Yes, I'd say the earlier email of the 14th of June amounted to notification.
Yes, I see.
And we'll see. One of the Warsame, I don't think I need to trouble the court with too much, but there is in Warsame the letter that is the confirmatory letter was criticised in that case, and it was found to be sufficient. So it may be after
sufficient for notification.
Turned away. Yes. So.
But there's not a new decision, confirmatory decision, every time the local authority reiterates its position in the same terms under similar circumstances.
My lord, no. I'd say that I'd agree with that. I'd agree with that summary. Because that is the key. That is the distinction between decision and notification. So the local authority had decided, in my submission as of the 14th of June, that the duty had come to an end, so far as the refusal was maintained. When it reiterates that position afterwards, I suppose I don't need to go so far on my case to say whether those subsequent decisions would in fact have been reviewable or not. I suppose if one was to take the view that the 14th of June email for some reason was insufficient, then we could rely the next letter in the chain would become a decision its own right and then reviewable, rather than a reiteration of a previous decision or a notification of a previous decision.
So would that be the 7th of October?
My lord, yes.
There is the August communication.
Yes, cancelling the temporary accommodation.
Where you say, well, implicit in that was the local authority thought its duty was over. So could that amount to notification of a confirmatory decision?
Potentially, my lord, it could. And I don't put it higher
so
than that.
The way it's looking, as I understand it, is that your first position is that the email of the 14th of June is where your decision making, as it were, came to an end.
My lord, yes.
But it doesn't. You don't need to succeed on that, and you could be compelled to concede that the 19th of August or even the 7th of October were further decisions which might have been reviewable.
My lord.
But it's all the same from the perspective of the proceedings out of which this appeal arises.
My lord, yes. That's a fair summary of my position. Just for your lordship's reference, the relevant part of Waltham yes, is 703 B at page 245 of the authority's bond. So actually, the text of the letter is quoted at 244 under at H. And at 245B, it's the thrust is said to be clear enough of the letter, and it's similar in my submission in terms to the various pieces of communication that postdated the offer.
So the ratio of Waltham Walsamy is that the wide words of 202.1b were apt to include a decision that a duty once owed was no longer owed.
My lord, yes. Because what was being argued in Walsamy was the words a decision as to what duty, if any, is owed, where the decision was that no duty is owed, that isn't therefore a reviewable decision. I mean, one can well see why the court took the view that it did in my submission. But yes, so that's why Ravichandran relies on Walsamy to say, because the confirmatory decision, as it's put in Ravichandran, is a duty that a decision that was once owed is no longer owed. That's why Mr. Arden's point was misconceived, because he was saying because the duty came to an end at law, a subsequent decision that says the duty's come to an end isn't reviewable, and the court said the answer to that submission is the ratio of Waltham.
So then you do need, on that thesis, to distinguish between a confirmatory decision and, you would say, a reiteration of the council's position.
Yes.
In one sense, one might say, well, there isn't much difference because on your case, the duty has come to an end anyway.
Yes.
So the first time the council says that, it's of no legal effect. But the first time the council says it, you would accept is reviewable. But if the council goes on saying it, it's not reviewable.
Yeah.
My lord, yes.
So if you say no, and then you say no, and then you say no again, you can be reviewed on the first time, but
Yes.
unless the circumstances have changed, and you've been provided with other information that ought to be considered.
Yes, unless it's genuinely a sort of fresh decision, as it were. Yes. Because the local authority would be at liberty to withdraw its earlier decision at any time and make a new one. But yes, and anyway, on the fact, I suppose on the facts of this case, in my submission, it doesn't need to go that far, because what I say about the alternative remedy point in relation to the possibility of reviewing the offer itself as regards the legal error that was ultimately relied on in the judicial review. But otherwise, I would accept my lordship's summary. Yes, there can be. There doesn't need to be a confirmatory decision. Where there is a confirmatory decision, it is reviewable and appealable.
And just, I haven't looked in Ravichandran. Is there any discussion of alternative remedies?
Ravichandran is a appeal a statutory appeal.
It's a statutory appeal, so they didn't need to consider it. No. Yeah.
And again, I don't think there's any difference between us on the applicability of the alternative remedy rule, if I put it that way, in Housing Act appeals. That the case law is clear that absent some exceptional circumstances, where there is a route to review and appeal, a judicial review will be refused permission.
Yeah.
So yeah, so I think that is ground one, and probably most of ground two is from me, my lords. My learned junior was going to address the court on and take the court through where the offer letter hits the statutory preconditions under section 1937 AA, and I wonder if that might be a convenient time.
Yes, as you like. Yes, Mr. Mann.
Grateful. My lords, essentially the point I want to address you on is at paragraph 70 of the respondent's skeleton argument. But in a sense, it's looking at it in reverse.
7-0.
7-0. So this is on ground two, and it's saying effectively if we concede or if you decide against us, the decision is required. What are the requirements of that decision? And you can see at paragraph 7-0, and we say this is erroneous, you can see there that the respondent has effectively sought to impose, firstly, that a decision has to be made, but secondly, that decision has to satisfy a whole raft of additional requirements, and those are listed there at A to G. And I know, of course, that a number of those have sub-numbering as well. So we say that it is outside the statute and is against the statute, and also there's no basis in the authority for imposing a decision that satisfies all those requirements. And the reason we say that is because there's no authority in the case law for it. My learned senior has already taken you to the cases of Waltham and Ravichandran, and essentially the elements of those cases that I would have taken you to were the same points that my learned senior were going to take you to. Just to do that in a very headline sense, in Waltham, the initial letter, which was dated the 5th of February, that letter was in fact criticised by the court. They said there are a number of criticisms that could be made of it, but in fact it is sufficient to get the thrust across. They say there at paragraph 703B of the law report, the thrust is clear enough. The council was intending to treat the refusal of accommodation as a ground for bringing the duty to a close. So that's what Wasame says about the requirements of a reviewable letter, if any. Then turning to Ravichandran and the characteristics of that letter. Well, Ravichandran is clear of 2 points. Firstly, that there can be a letter which is a prospective intention to bring the duty to an end is a reviewable letter. And secondly, applying the ratio of Wasame, that a second letter, even if only confirmatory of a prior automatic discharge, is also reviewable. Then, dealing with the way the High Court dealt with this, the critical paragraphs, and I can take you there, it's in the 4 bundle. The judgment begins at paragraph 61, and the paragraphs I want to take you to are 74 to 76, which are at page 78 of that bundle. '74 is where the learned judge says that the council must reach a decision, that is, reach a conclusion whether the duty is ended. And he says, in fact, there was no decision in this case. And then 75 and 76, which are of course critical to the case, but just to go straight to 76, he says in this case there was a lack of a clear and effective decision. So I must mention the learned judge, he effectively imposed a secondary decision on the local authority without considering what the requirements of that decision might be. The closest he gets to doing so is paragraph 76, where he says, well, it must be clear and effective. So in my submission, the thrust of all of these points is that if a decision is required, it need only be, to use the language of Ravichandran, confirmatory. To borrow the language of Wasame, it must confirm that a duty once owed is no longer owed. In Wasame, again, the thrust needs to be clear enough. And even in the language of the High Court, it's got to be clear. And in my submission, the documents that you've gone through, and I won't go through those in any greater detail unless I would assist the court, those amply satisfy all of that guidance.
Right. So, in a nutshell, if you're wrong about there having to be a decision, you say what you made at the time was a decision, and that the list provided by the respondent at paragraph 70 is not called for.
Exactly.
Otherwise, presumably you'd go on to say there'd be no end of discussion about whether something was or was not a decision.
Exactly.
Sorry.
No.
There's a sort of twist to this, because the judge says, well, you don't require notification, you require a decision. The communications we've seen might or might not be notifications, but they don't need to be the decision. So in theory, you could have put in evidence explaining what had gone on internally, what the thought process of the council internally was, but we don't have that.
Well, I would say, my learned senior may add to this, I would say we don't need to.
Now, I follow you say you don't need to, but we haven't got a witness statement from a relevant officer explaining this was what they thought.
Well, we do have the witness statement of
Mr. Eggbomb.
Mr. Eggbomb, exactly. And that's in the supplementary bundle, I believe, towards the end. Beginning at page 51 in the supplementary. Paragraph 5 is really the critical point in that.
So the suggestion might be, well, paragraph 5 shows that internally the council decided that the duty was over because it closed the application. So I don't know how that would relate to Ms Davis's requirements in paragraph 70.
Well, we would say that there's no basis for imposing those requirements.
No, I follow that. But
You
supposing there were a basis, I don't know how I mean, we know from Mr. Eggbom, seemingly, that the council closed its file, reflecting presumably the thought that the duty was over. We don't know about all these different bits of paragraph 70 in that context.
That's right. We don't know what happened internally. Other than that, it was felt that the duty had come to an end by virtue of the refusal. Then there was the email of 14th of June, and then it was 19th of August and 7th of October, and of course the cancellation of the accommodation. We can't say exactly what happened internally. There is, of course, the presumption of regularity, which we relied upon. It's not said that something irregular happened internally. It said that no decision was made at all.
Is there perhaps a distinction to be drawn between making a decision and making a lawful decision on the question of whether the duty continues to be owed? I mean, paragraph 70 of the Respondent skeleton sets out the requirements that it proposes by reference to the statute and the statutory requirements. And so there's some logic in saying that those are things that have to be the case in order for a lawful decision to be made. But that doesn't necessarily mean that it's not a decision. It's just be an unlawful decision which doesn't take account of all the relevant factors.
I'm gratefully going to defer to my learned senior officer.
I'm grateful. My lord, I'd agree with that. But that shouldn't be taken, my lord, as a concession that the factors set out at paragraph 70 are necessary in the confirmatory decision, because all of them, and when one looks at them, what they ultimately are the statutory preconditions that have to be in place prior to the offer being made in the first place.
Yes, they've been disaggregated. I mean,
yes.
You've got to have an offer.
Yes, and
a refusal or acceptance.
That is the one thing.
And we now know the Norton notification. Those seem to be. You could boil it down to those three things.
Indeed.
Or you can disaggregate it in this way and make it into quite a lot of different things.
It gets odd, because supposing you can't make a decision without satisfying all these requirements, then there is nothing to review. I mean, there is no decision. It's only if there is a decision that you can ask for a review in which you can point out the imperfections.
Yeah, well, what you can review is before I come to that point, so the last domino to fall, the only thing that will have changed between the offer and the confirmatory decision will be whether there's an acceptance or a refusal. So necessarily, and that's the point my learned friend presses on the court, is that you must have this decision, because otherwise how can someone bring a challenge where they say, but I didn't refuse it?
But a decision which says take it or leave it is still a decision.
Indeed, my lord. And the reason why, if this list were right, what the decision wouldn't be confirmatory really at all. It would be a sort of mini review.
Well, the second decision would be you left it or you took it.
Yes, and that's all that's needed, because the point my learned friend's making at paragraph 70 is that second decision, the confirmatory decision, needs to do all these things, and we say no.
What I'm struggling with, and which might suggest that I'm not clear about this, but might suggest that the judge's solution is the worst of all possible worlds, is that you have to make a decision, but you don't have to communicate it.
Yes, well, that certainly wasn't our case below, my lord.
But I can see. I mean, I can at least see some logic that if you've got to both make a decision and then tell them that you've made a decision afterwards, once they've had the chance to reflect on your first decision.
Yes.
That you've got to make a second decision which says, now we've heard from you, we make this decision. But to be in a position where you have to do the second thing, but you don't have to tell them about it, because the statute plainly doesn't require that.
Yeah.
I can't really see the point in that.
Well, no, but I would respectfully agree. What I'll do to end, and perhaps it's an unusual way around of doing it, but what I might do to end is just to highlight a couple of parts of the court's below's judgment.
I'd like that, because I'd like to have from both of you your identification of what the key points in the judge's reasoning are as he goes through what's quite a substantial judgment.
I'm grateful. I'll do that now, my lord, to end. Of course, in homelessness appeals that are statutory appeals, the focus is on the review decision, but of course here, because it's an appeal against the decision of the administrative court, the focus is on rather than necessarily on the underlying documents, it's on the decision of the court below. Looking at the judgment, my lord, as my lord junior said, starts at page 62 substantively. It accurately sets out in my submission, summarises at that stage what the parties' positions were. And we were relying, in the court below, the local authority was saying, you're out of time, there's no good reason to extend time, and there's, you in any event had an alternative remedy, and in any event there's undue delay, and granting relief would offend the principle of finality and be detrimental to good administration. At paragraphs 9 to 12, again, accurate in my submission.
Well, and you had your floodgates argument.
Yes, indeed, my lord, yes.
Yes.
And 9 to 12, the learned judge deals with my criticism of the way that the judicial review was brought. So, and that's again something the court we've touched upon already. I say that the ground that's identified as under challenge, the decision that's identified as under challenge in the claim form is a red herring. What's really
So the first question that the judge addresses is, what is the decision?
Yeah. And I read, given the framing of the judgment, that he, to some extent, engaged with or accepted my argument that one had to look back beyond that decision to what happened in June 2020 and onwards. And without jumping forward, the learned judge ultimately concluded, because there was this need for a second decision after refusal, and on his learned view we'd not made one, all of our arguments about relief fell away, both in terms of time limits, undue delay, and alternative remedies. And I'll come to those parts of the judgment, but just a headline, that's where the judgment ultimately goes. The legal framework is, again, in my respectful submission, accurately summarised between paragraphs 13 and really as far as 31. The only issue I would take is at paragraph 26 of the judgment, page 68. The learned judge said, once more the Court of Appeal emphasises decisions about factual situations, such as relevant elections following offers, if they have occurred or do exist, will have the effect that the duty ceases. Therefore, Waltham provides powerful support for the proposition that the Local Housing Authority must make a decision whether the main duty under section 193 subsection 2 is ceased, rather than it being something automatic. And I don't accept that proposition. I don't accept it provides powerful support, because as I've already submitted, what Waltham and Ravichandran are doing is saying is whether a decision is reviewable, not about whether a decision is necessarily required as a matter of law under the Act. The other point I would highlight, my lords, is at paragraph 30 of just over on the next page. The learned judge says, thus a distinction is drawn between a prospective discharge duty by the making of an offer as against the decision by the local housing authority that there has been a satisfaction of the conditions of discharge. Both decisions are reviewable. So the learned judge below accepted that a prospective decision as to duty is reviewable. I think he was right to do so, because that's what Ravichandran says, but to the extent that it's argued against me in this court, the judge below found that both those decisions were reviewable, and there's no respondent's notice. So I would say that it wouldn't be open to the respondent to this appeal to say, actually, the offer is only reviewable on suitability, it's not reviewable on duty. Because the judge found, as a matter of law, that both decisions are reviewable.
And you don't have to challenge that insofar as it relates to decisions made in 2020.
No.
If they're to be characterised as decisions.
My lord, no.
I mean, he obviously goes on to say that's not to say that a prospective discharge is sufficient to bring the duty to an end, whereas you say it is sufficient to bring the duty to an end.
My lord, yes. But again, that's in terms of the. I say that doesn't matter because in terms of the alternative remedy, if you can raise that point at that stage, that's your alternative remedy. You fail to utilise that remedy, then you're shut out from judicial review, absent exceptional circumstance.
Right.
Then
we have remedy of last resort. That's the law.
Yes, and that's the law. Although there is some further discussion of the law. So the judge also, paragraph 34, just in case it's relevant, the final couple of sentences deal with the WhatsApp message, so the beginning of the refusal. And then the message is the 14th of June. The claimant did not consequently travel to Derby on the 15th of June. The claimant accepts that the accommodation was refused.
What paragraph are you reading from?
That's 34, my lord.
Thank you.
Page 70. So discussion starts over the page, page 71. And again, I wouldn't demur from the setting out of the issues here too much. I've tried to identify, the judgment does tend to swap between a decision recognising that the duty had come to an end and a decision to bring the duty to an end. And that's an important distinction because there are times where the decision itself is what ends the duty, is what ends the duty, rather than the satisfaction of a factual scenario. And I flag it because, and I'll give a few references as we go through the judgment where that happens. But if it was thought that our case was that the decision in some way ended the duty, any of the decisions in question, or I should say alleged decisions perhaps, they were what ended the duty. That wasn't our case. Our
That
case
wasn't
was
the case under the previous version of the legislation, was it?
No.
It was notification that
No.
brought the duty to an end.
No, I think there are other situations under the Act where it can be that the decision is operative in that way, but not under the provisions that have been discussed in the authorities we're dealing with here. And it certainly wasn't our case, or I think with respect necessarily to the respondent, their case, that there needed to be a duty to bring the decision to an end. What they were saying is there needed to be a decision that the duty had ended. So it's also said that we had conceded, paragraph 52, I'm on page 73 now. So what is said to be the issue at the heart of Miss Bano's claim is that the defendant did not in fact make a decision that the main duty was ended through its chosen route, and such a decision was necessary to end the main duty. And the statutory conditions for the main duty to cease were not satisfied. The defendant submits the LHA made such a decision, or to the extent that's set, to the extent the judge was recording that we were saying there needed to be a decision for the duty to end, that's not right. We didn't.
You said if you needed to make a decision, you did.
Indeed, my lord, yes. In pressing for this characterisation, it was implicit in the defendant's analysis that it accepted that a decision needed to be made that the main duty ceased to be owed. No, I would respectfully disagree with that. We didn't concede that. moving through the letter, the judgment, the paragraph 55, the learned judge says, with reference to Waltham, that this decision that the main duty of ceasing can be subject to review and indeed further legal challenge if it's legally erroneous. I'd accept that. For example, if a local housing authority concluded the main duty were ended, but had not complied with the conditions set out in the statutory provisions, that ending decision would be legally flawed. However, it would appear puzzling if the relevant local housing authority could proceed to act if the main duty were ended without making a decision that it in fact had come to an end. I think this is part of the complexity of this case, or what the court's been grappling with today, is decision in one sense suggests it imports a degree of formality, and I say a local authority doesn't necessarily need to decide, particularly where it's agreed and has always been agreed that there was a refusal. It doesn't need to make a decision as to a refusal. Or that
the statutory state of affairs.
Indeed.
And quite often in judicial review, the thing that has been done that is under review is an act.
My lord, yes.
And it's characterised as a decision because that's the sort of shorthand that we use in judicial review. Yeah. But, or it may be an omission, a failure to act.
Yes. And I suppose the claimant's case here is that the failure is to comply with the ongoing main housing duty. But one could challenge the failure to do that by reference to one would bring that challenge with reference to a decision saying we're not going to do it. Yeah. And so yes, and really, when my submission, I think given I've made my submissions already, when they're layered onto the judgment, will become obvious what my
right. You take issue with 55 as a whole.
Yes. Yes, and it's only that the decisions were challengeable in Waltham and Ravichandran because those decisions have been made in those cases. One, in a statutory scheme that necessitated a second decision in Waltham because there had to be a decision post the offer under those statutory provisions. There was still an automatic ending, but there was necessarily in Waltham a two-step process.
And the jump in logic that you object to is it's one thing to say that a decision is reviewable, but it's a different thing to say that you have to make a decision.
Indeed, my lord has it.
I'm just coming back to a point my lord mentioned earlier. I mean, in a way, this all looks particularly problematic if you envisage that an offer is accepted. So if you envisage a scenario where an offer is made and it is accepted, the local authority wouldn't necessarily think it needs to do anything at all more, would it? It would just think that, if it made the offer, it had been accepted, the duty would come to an end. I'm not sure why it would think it needed to do anything more.
No, I think it would be it may be that I don't see these cases where these letters are sent because they don't come under challenge, but I think, my lord, I would agree that's right. It would be odd for a local authority, in addition to them going to the property, signing the tenancy agreement and moving in, to send a letter that said, oh, just by the way, the main housing duty is ended. I agree, or a separate decision to put it as high as it said it needs to be put.
Well, you could have a situation which we've got here on one view, where there's a communication which is ambiguous and might, on one view, amount to a request for a review, which would keep the duty alive.
Yeah.
And then you've got the authority saying, well, that wasn't actually a valid request for a review.
Yes, I'm not sure it would.
Would it keep the duty alive?
I'm not sure it would keep the duty alive. I think what would happen is the review may withdraw the earlier decision because on a review as to duty following a PRSO, the reviewing officer will either say, yes, we're satisfied the offer was suitable and we're satisfied that the preconditions for duty coming to an end were there, therefore the duty is to an end, or it will say, having looked into the matter, actually the offer was invalid for the reasons you say, and therefore the main duty continues. And that will, again, I suppose, be a reflection of the true state of affairs rather than something that the reviewing officer is determining. The reviewing officer will say, actually, having looked at this again, the duty didn't come to an end because our offer was invalid in the Norton situation. And that post-Norton one, as one I'm sure can imagine, post-Norton there were an awful lot of those sorts of reviews going on.
Right.
But yes, my lord, there are only a couple of other references to the judgment. I'll just take the court to. The defendant also accepts that this is at paragraph 60 of the judgment, the final two sentences, page 75. The defendant also accepts that this offer, due to its legal effects, did not bring the duty to an end. I suppose I do accept that in the sense that I'm saying it's automatic, but not in the sense that when we're dealing with the offer, I had never suggested that the offer letter brought the duty to an end. It was setting up the dominoes for the acceptance or the refusal to bring it to an end. And it was reviewable, as he had found, as the learned judge had found it earlier in his judgment, that the prospective intention decision was reviewable. Paragraph 62 is where the learned judge deals with the email and the WhatsApp message from 14th of June. And again, it's correct, I didn't submit it was a decision to end the main duty. It was included in the bundle as part of the contextual documents that set out what had happened afterwards, a reflection of the view the local authority had taken. But I'm not sure it's right to say, as the learned judge there, that it predated the refusal of the offer. And paragraph 64, which is the learned judge's starts discussion of the 7th of October 20 letter. Third sentence is, Mr. Mullins submits that this is also a decision to end the main housing duty. Again, no, I didn't, but and this is, I've already made submissions on this about why the learned judge was wrong, but he takes the view that the reference to section 1935, which I said was erroneous, is significant. And paragraph 69 is, I suppose, an important part of his conclusion on that. This is plainly what the letter was principally addressing. It did not purport to be a decision letter about ending the main housing duty under section 1932. And I agree, but what it did was recognise that decision, what it recognised is that the local authority had already taken that view.
Well, because you can only have a review decision if you've had a
initial decision.
Initial decision.
Yes.
It was about a review.
Yes, a proposed review of the offer.
Yeah.
I think it's fair to say. So, what was said to be? So they had said, our client's daughter sent a WhatsApp. A review request by WhatsApp. Are you dealing with it? And they wrote back and say, we didn't get a review request by WhatsApp and you're out of time. And we suggest, and our housing duty to you is finished. And we suggest you need to find alternative accommodation, in effect. So it was recognising that it's implicit, if it's not explicit, it is at least implicit in that letter that the main duty had come to an end, and that was the view the local authority had taken. Automatic ending starts at paragraph 72. Paragraph 73, the judge says, it seems to me there are a number of problems with the notion of an automatically ending duty without any LHA decision or action. it is for the LHA to assess whether there has been an offer or acceptance. It must make a decision about that. That decision is then challengeable. I don't accept it must make a decision about that for all the reasons I've said, particularly in a case where it's
When he
always
says
agreed.
offer, does it mean refusal, really? It's for the local authority to assess whether there's been an offer or acceptance. I mean, on the face of it, it would make better sense if it were refusal or acceptance.
Yes. Or it may be offer and acceptance, because I suppose.
Yeah.
If they're an automatic ending, when would the time run for the purposes of a challenge? If it's upon refusal, when is the refusal?
And I think on your case, time wouldn't run from refusal, would it?
No. Time can never run from the refusal. Time would run from some act of the local authority, and it depends which route one is taken. If it's a Section 202 review, time began to run from the offer, and if there was a second confirmatory decision of the type envisaged by Ravichandran, it would run from the notification of that decision. For the purposes of judicial review, if there was some dispute about acceptance or refusal that couldn't go through the 202 review procedure, there would still be the remedy of judicial review, and time would begin to run in the ordinary way, because the local authority would, if someone was saying, "Oh no, I didn't refuse it," then the local authority is inevitably going to communicate that to them in some practical way, and time would start to run at that point on ordinary judicial review time limit principles, in my submission. So yes, paragraph 75 is his conclusion on decision, and the learned judge says the net effect of this analysis is that neither the 11th of June nor the 7th of October 2020 letters are decisions by the defendant ending the main housing duty. And it was never my case that they were, but I judged that what the defendant has sought to do is promote the original offer letter into an ending decision. It was not. It was attempted to convert a letter by a review officer refusing a requested suitability review into an ending decision. Once more, it was not. This is why the defendant sought to argue that its official had cited the wrong statutory provision, when in actuality she cited the correct provision. What is lacking in this case is precisely what existed in Norton and Waltham, a decision to end the main duty. And then I think I needn't take the court through delay and.
Right, because that paragraph 75, as it were, completely pulls the rug under all of your arguments.
Indeed.
It actually contains a third version of the decision. You said bringing the duty to an end, and that the duty has come to an end. This is a decision.
An ending decision.
To end the main duty.
Yes. The last part I take the court to is only because it's my sort of central point is about alternative remedy, which is dealt with at paragraph 86. And at the first part of that paragraph, and in the legal section, the judgment, the learned judge correctly, I think, identifies the Crown and Brent London Borough Council and O'Connor and Merton London Borough Council ex parte sembi as the two relevant decisions, that says there is unquestionably in this case a relevant statutory regime in Glencore terms. However, its applicability is based on the assumption that the decision to be reviewed was contained within the 11th of June 2020 offer letter or the subsequent letter of 7th of October 2020. Such an ending decision could be subject to statutory review and then right of appeal on a point of law to the county court in the usual way. in the absence of challenging the decision in the way prescribed by appellant, the claimant needs to demonstrate pressing exceptional circumstances. Given this court's decision, I'm skipping down over the case references. Given this court's decision on the prime question about the continuation of the main duty and the failure to make an effective decision that it was ended, these arguments about alternative remedy fall away. The fact is, the main duty has not been brought to an end, as Lang LJ termed in Norton, in accordance with the statutory ending conditions. A fresh application is not an alternative remedy. The question of whether Miss Bano still qualifies as a priority need would require reconsideration. What that doesn't deal with in my submission is my argument that the offer letter itself was reviewable. It says, because it seems that in the absence of, because there wasn't a decision that the main duty had ended, as opposed to a decision that the main duty would end, which the learned judge accepted earlier in his judgment was reviewable. It doesn't grapple with why that's said to not be a suitable alternative remedy.
So you say, actually, on this argument, it really doesn't matter whether there was an obligation to make a further decision, and it really doesn't matter whether a further decision was made, because it was always open to Ms. Bano to take the Norton point,
yes,
in relation to the offer letter, and there was a perfectly good mechanism for that by way of review.
yes, and she could have taken that and gone right the way through the same legal process that those reviews and appeals follow.
But it isn't a case, when we look at this, where the judge was saying, in case I'm wrong about the need for a bespoke decision, a bespoke ending decision.
Yes.
This is what I say about alternative remedy. He doesn't do that. He as it were, redoubles the argument in relation to alternative remedy by reference to what he did find.
My lord, yes.
And so we don't have, as it were, the advantage of him saying, if I was wrong about that, I wouldn't give permission because of the alternative remedy.
My lord, I'm afraid not. No, I think that the one time that there is a sort of, I'm struggling to remember where it is now. My learned junior might be able to help me. There is a sort of, if I'm wrong about that clause in the judgment, but I don't think it touches. I haven't taken your lordship's to it because I don't think anything turns on it. But I think, unless I can assist your lordships any further, I think those are my submissions on grounds 1 and 2.
No, thank you both very much.
I'm grateful.
Yes.
My
Miss
lords,
Davies.
can I start with why we're right to bring a judicial review against the decision of the 30th of May 2023? And just in terms of delay, I don't think it's suggested that we delayed in judicially reviewing that decision. The question is whether we're right to try to challenge that decision. And the answer to that lies in the judge's finding at paragraph 76 of the judgment, page 78 of the court bundle. The lack of a clear and effective decision by the defendant to end the main duty is significant for the delay argument. And Mr. Mullins's argument has been that, leaving aside alternative remedy and review, which I'll come to in a moment, but that if we were going to judicially review a decision that the main housing duty had come to an end, we should have done so within 3 months of one of the various communications in 2020.
Yep. But is this, before you embark on this, can I just understand, this isn't really to do with delay, is it? Either there was a decision in 2020 or there wasn't.
Yes.
Either because it's automatic or because of something that was decided.
Yes.
Or there was a decision in 2023, and if there was a decision in 2023, then you weren't out of time.
That's right. So,
So it's
we
not,
say
it's not the delay argument, as it were, is it's not an argument that could help Mr. Mullen if he didn't have a decision in 2020.
as I understood Mr. Mullen, and if I am misunderstood, I'm happy to be corrected and I don't need to make the point. But as I understood him, he was saying that at some point in 2020, as a result of the various communications, which we do, I'm afraid we will need to look at again, Miss Bano, properly advised, was told that the decision was the duty had come to an end. And either she could have availed herself of a review of that decision under section 2021B, so that's his alternative remedy point, or she could have judicially reviewed a later, as it were, my lord referred to saying no, no, no several times, a later decision saying no, we have previously ended the duty. And we say that that later decision was not expressed clearly and effectively until the decision of May 2023. We're not out of time if it's the 30th of May 2023, and therefore there is no delay. So that's our case. But if I'm right that Mr. Mullins is saying we should have been judicially reviewing the earlier decisions in order to say you're wrong, the section 193 duty has not come to an end, and also that there was an alternative remedy at that point, we do need to look at whether those decisions were, as the judge put it, clear and effective. And so perhaps I can start with that, which also probably may encompass some, perhaps all, but I don't want to stake myself on it, of ground 2, and then come back to ground 1 after I've done that.
By all means.
So in terms of the decisions, we start with the offer at page 5 of the supplementary bundle. And we say that the judge was right to characterise that exactly as it is headed at page 5. Offer, one has to read in the word of, accommodation to end main duty. So it is an offer. It is no more than that. It then does set out some of the information that is required under section 193, 7AA and AB. And it concludes that this was a private rented sector offer as defined by section 193, 7AC. And as we know, the authority of Norton made it clear that at page 6, it's defective. There is that Norton deficiency, and that the whole of section 195A, subsections 1 and 2, are not fully set out. But and so many of the elements that are required to end the duty are dealt with in this offer, not just suitability. But what is not made clear to my client, what is not said, and indeed we would say therefore is not decided or intended by Waltham Forest, is that she has the right both to request an offer of the suitability of the accommodation in Derby, which they tell her about at page 6.
You have the right to request a
review of the suitability of the accommodation. Yeah. And they tell her about that at B on page 6. You have a right to request a review of the suitability of accommodation offered. I must also inform you, even if you accept the offer, you can continue to request a review of our decision, and that the accommodation offered you suitable under section 2021F. So they are right to say that happens. They've got the section slightly wrong. It's G, not F, but nothing turns on that. And that is a review solely of the suitability. What that does not give Mrs. Bano is the right to request a review of any of the other matters set out in this decision letter. And specifically, as we now know following Norton, whether or not they had fully complied with section 193 7AB, and they had informed her of both elements of section 195A. Because nowhere in this letter does it say you have the right to request a review of our perspective in the way that Mr. Mullins phrases it, or intended decision that the duty has come to an end. She is only told that she has a right to request a review of the suitability under section 202, what should be 1G. And then page 11, if you wish to request a review, you must put this in writing within 21 days. So she's told how to request the review, and she's told that she can have a review on suitability, not anything else. Right. And on Mr. Mullins's case, as I understood it, leaving aside ground one, if, and I accept he's taking issue with the judge's findings, that he had said that this was, he had submitted a decision. I understand that. But Mr. Mullins's case was that this letter was sufficient for my client to be able to request a review of the whole of the elements of section 193, 7AA to 7A6. And quite simply, it's not. She's simply told that all she can have is a review of suitability.
So just, this may take you into matters you're going into this
Yes.
afternoon, but just so I understand the context, do you say he's wrong about that? Do you say that it was impossible to ask for a review in respect to the other matters?
I do, because my primary case, and it's under ground one, is that a local authority cannot be satisfied that the conditions for the duty ending have occurred until post-offer, because they do have to make a decision about, at the very least, refusal or acceptance post-offer, and that can only happen post-offer, clearly.
Can I just break that
So
down?
that's my primary case. But
Yes.
if I'm wrong about that, and if Mr. Mullins is right about the opportunity in an offer letter to review under section 2021B, I do apologise, a decision that the duty has come to an end, if he's right about that, then she was not given that opportunity in this letter.
So can I just break down the different things? At this stage, presumably you would accept that the local authority has made a decision to make an offer which is capable of bringing the duty to an end.
Yes.
Then the next question is that decision itself capable of being the subject of review except on suitability grounds? To which you say...
I'm sorry, you've lost me a little there.
Is the decision made at this stage capable of being the subject of a request for a review other than on suitability grounds? And do you say no, it can't?
No, it can't be, because the whole of the conditions include a decision about refusal or acceptance. But if I'm wrong, my lord, and this communication does constitute, as Mr. Mullins put it, a prospective decision that the duty has ended, on the grounds that there is no decision to make about acceptance or refusal. If I'm wrong, she's not given that opportunity.
So can I just break that down? Is it that it's, on Mr. Mullin's case, a prospective decision or a decision that will have prospective effect? It's a decision now, isn't it?
Yes.
I don't think that's the question for me. I can't answer that.
Okay.
My submission is very clear that the decision as to whether or not the conditions have been met can only be made after acceptance or refusal. Now, certainly a local authority could, as it were, have a checklist that 80%, 90% of the matters to be considered have already been considered in this offer letter. And they could either repeat the checklist, or I suppose they could say, we have already informed you about. But they do actually have to make a decision following acceptance or refusal. And it's that decision that carries a right to request a review under B.
And that you're coming to this afternoon.
And that I will come to this afternoon.
Just coming back so I understand this point. You say, well, supposing you're wrong and that this letter could be the subject of a request for a review other than on suitability grounds.
Under B, yes.
Under B. You say, well, still, Miss Bano wasn't told about that.
No.
Now, what on your case is the consequence of not being told?
The consequence is that it cannot amount to notification. And I'm aware of the difficulty in the judge's judgment about notification. I'm aware of that. But what we do know is that there has to be notification of a decision in order for the time limits to run, and that's section 2023.
But 202 doesn't. 202 says you have to notify the decision. It doesn't say you have to notify the right to review.
2023 says time limits start from notification. It doesn't. It's page 69 in the authorities bundle. And it's about halfway down the page, just above Wales.
I've got a separate printout because I find it easier than the Westlaw pages and pages and pages.
It's section 2023, my lord.
So that says you have to notify of the decision.
No, that says that time limits
runs from notification to decision.
It doesn't say what notification entails.
Yes,
it says that the time limit for request for review starts at notification.
Now here, Mr. Mullin, I think, would say, well, look, even if the letter didn't point out that there was a right to review, it notified Mrs. Bano of the decision. So is there some other provision saying you have not merely to notify of the decision, but you have to notify of the right to ask for a review?
There's nothing in section 193. And it could well be, what this case has possibly highlighted is something of a lacuna in section 193, both about the lack of notification, which is problematic, and also about the lack of what details should be notified. We do know that in general decisions at section 184 that there is requirement as to what needs to be in notification. And that's section 184 for my other lords. It's page 16 of the authorities bundle. 16, yes, thank you. And we know that a section 184 decision, which is a decision as to what duty, if any, is owed to the applicant, at subsection 3, on completing their inquiries, the authority shall notify the applicant of their decision, and so far as any issue is decided against his interest, inform him of the reasons for their decision. And at subsection 5, a notice under subsection 3 shall also inform the applicant of his right to request a review of the decision and of the time within which such a request may be made. So a section 184 decision, which my lords know is the earlier decision, in fact we have it in the supplementary bundle as to what duty is owed. Do you have a priority need? Have you become homeless intentionally, and so forth? That's a very clear structure which leads to an applicant knowing that she has the right to request the review, knowing when to do it, and knowing how to do it, and knowing why the decision, because of the reasons. Section 193 does not have that. And
does it have it as to suitability? I can't remember. Are you supposed to draw attention to the right to a review of suitability, or not even that?
Yes. Yes, my lord's absolutely right. So in section 193, at subsection 7, where it's refusal of a final offer under part 6, an allocation, the applicant has to be informed of the possible consequence of refusal or acceptance and the right to request review of suitability. And at 7AA, it's in 7AB, 7AB little b, then the applicant has to be informed that they have a right to request a review of the suitability of the accommodation.
Yes, that's
So they have to provide that, but there is nothing in section 193 that says you have to be informed of your right to request a review of the decision that the duty has come to an end.
I follow that. So,
And that's difficult, given that we know there is that right under Waltham and Ravichandra. That is difficult, and I accept that's difficult. I'm sorry I cut you off.
no. Well, I think you are answering the point. So it would make sense for there to be a provision drawn more widely, but it isn't there.
Yes, it isn't there. But that doesn't alter my point that even with the absence of the statutory requirement in section 193, it's impossible for the offer letter of the 11th of June to be read as offering a review for anything other than suitability, because that's what they say.
But what's the legal? This is not necessary for now, but it would help me to understand the legal basis. What appears to be a submission, which I think is new, that the even on the local authority's case, the offer was invalid for want of a notification of a right to review of the validity of the offer.
No, that's not my submission. I'm so sorry.
No,
If I was unclear, I do apologise. We say the offer's invalid because of Norton. That's a different point.
that's different.
What we say is that insofar as Mr. Mullins is relying on that letter as evidence of a decision that the duty has come to an end, that the problem for that is that she was not told that she could have a right to request a review of that. And if I may, very quickly, in order to confirm that point, I just want to look at very shortly the other three communications, and end with that of the 7th of October, because the communication of the 14th of June, page 13, insofar as that's being pointed to as a prospective decision that the duty will end, not that the offer was suitable, but that the duty would end, again, my client would have no idea that she could request a review of that. Neither could she in respect of the communication of the 19th of August. And when we come to the 7th of October, and this is my final point, that is, as we know, that's very clearly a decision saying that Mrs. Bano could not request a review. A request for review out of time was refused. Sorry, it's two decisions. It's a decision that there was no request for review made in June. And it's a second decision that a request for review will not now be accepted by Waltham Forest out of time. And throughout that letter, the review referred to is referred to throughout as a review on suitability. And that's at page 18.3, where they're quoting the offer letter. The offer letter advised her that if she accepts the offer, she can continue to request a review of our decision. The accommodation offered to her is unsuitable under section 2021F. Again, it should have been G.
But
And
at
then
that stage, you weren't challenging anything, but
we weren't challenging anything. But and this, if I hope, is going to be my final sentence. If it were the case that Waltham Forest understood any of these letters, particularly that of the 7th of October, to be notifying Mrs. Bano of its decision that the duty had come to an end, then at the latest on the 7th of October, whilst they may be entitled, they were entitled to say it's too late for review on suitability, they could absolutely have said, but of course there is the avenue of a right to request a review of the decision that the duty has ended. And they didn't, and that shows that they were not considered, that none of those letters were considered as decisions to end the duty, and that the judge was right to say none of those are clear and effective. So our first clear and effective decision is that of the 30th of May, which is why we're here in judicial review.
Thank you very much. Well, we'll come back at 2:05.
Thank you.